Kia ora. The first step to sort of foot in the water for understanding the way the law works and what the law is, I think, is we'll have a look at some of the ideas that are introduced in Chapter 2 of that book called the New Zealand Legal System that I've given for you. And I thought I'd start by looking at what are called the various divisions of law. Now, the authors there have spoken about broadly two divisions of law. The first is what they call public law, and the second is what they call private law. And within public law, there's a number of different categories. So the first one they've talked about is constitutional law. And constitutional law refers to how the law in a particular country is created and how it's administered and promulgated. New Zealand is in an interesting situation in that it has a unicameral, a single chamber of Parliament, and Parliament in New Zealand is constitutionally able to pass pretty much any law it wants. This is different from lots of countries. There are lots of countries they have a legislative assembly, and then they have to have a Senate, and things need to be approved by the Senate, or they have an upper house and a lower house, or they have a president with some authority over some matters as well. So the decision making, the legislative, the power to actually make laws has lots of checks and balances in other countries, but it doesn't really have any at all in New Zealand. And one of the aspects of that is that not only is there no other decision-making body, but there's no kind of permanent standard by which that laws need to adhere to. That is, no constitution, no formal written constitution. So if you compare it to the system in the United States, for example, in the United States, the Legislative Assembly and Congress and the Senate and the President can't just do what they want. They can't make laws that they want because the court, the judicial system, can strike those laws down if the courts decide that those laws are counter to the Constitution, because the Constitution is permanent and is there before and beyond any particular group of people who are elected to office. That's the permanent thing, and the body that decides whether the laws that those elected representatives are constitutional or not is the courts, the judiciary. So this distinction between the judiciary and those who determine the validity of the law and those who make the law is an important part of that. In New Zealand, there's nothing really like that. There's no legislation that has that can't be overturned by a change of government. The closest we've come to that really was the Bill of Rights Act that was passed in 1990, and the Bill of Rights Act was sort of written in the form of that you might get in a constitution, that those basic rights that people have that should be protected and so on, and so it does have that sort of complexion. But the Bill of Rights Act is just like any other piece of legislation, and a government tomorrow could simply get rid of it if they wanted, or alter it. There's no entrenched, what's called entrenched legislation. There's no supreme legislation. Parliament in New Zealand can change anything it wants, and so Parliament doesn't. No one parliament can bind another parliament. Once a new government is elected, that government can do whatever it wants, and it isn't bound at all by any previous governments, which is an interesting thing about this discussion about binding referenda, because what is the constitutional status of binding referenda? that's sort of being talked about occasionally. There is no precedent in New Zealand for any law that is beyond the will of the current Parliament. So that's what's meant by constitutional law, and that has some important elements in terms of how the entire legal and political system function that we need to understand. The second one that's discussed there is what's called administrative law. And in administrative law, it's talking about the way government departments and statutory bodies and so on operate. Now, an example of that that's come out recently is the conflict over fish and game, and the Minister of Conservation making comments to Fish and Game, this body, about how they're behaving. Fish and Game is a statutory body. Fish and Game is an institution that is created by Act of Parliament with a particular statutory function to protect the waterways and so on. So it isn't just any old group. It's part of what's called the administrative law of New Zealand. It's set up by Act of Parliament and so on. Other examples there are the Health Practitioners Disciplinary Tribunal, and the Teachers' Council in relation to education is another body like that. It's formally constituted legal body that has powers that are delegated or that are given to it by acts of Parliament and by formal legal structures. So that's the second example of public law. The third one is an interesting one, and that's criminal law. And the interesting thing about criminal law is that what it essentially deals with are offences not just against people, but against society. So I know whether you see things on TV, people are talking about, are they going to press charges and all this kind of thing. In criminal law, people don't have to press charges. In reality, if it's a crime against the person, in order to make the case to prosecute people, the police need the victims, generally need the victims to give evidence, but they don't necessarily. I mean, in a murder case, for example, there's no victim there to give any evidence. But the point about the criminal law is that it is an offence against society. So it's the Crown, it's the police, it's Crown law that prosecute people. It isn't a dispute between people. It's an offence that people have committed against society, and society feels the need to punish and deter other people from behaving like this. And so, because it involves major sanctions of monetary sanctions and deprivation of liberty and so on, it is the area of law where the highest standard is required. So that's where you have the importance of things like people's right to silence, people's right to legal representation, the presumption of innocence until proven guilty, the fact that guilt needs to be proved beyond reasonable doubt. So all of those really, really ultimately high standards you find in the criminal law, because the criminal law is dealing with depriving people of what we see are essential human rights. The other one there is mentioned as revenue law, to do with taxation and so on. It's spoken of as a separate category, but we don't need to discuss that in relation to what we're doing in this course. So the second broad group there is private law. And the first category within private law is what's called contract law. And I don't propose to do a whole lot about contract law. Contract law is the law that regulates commercial practice and agreements between people. And essentially, a contract is formed by an offer by one party to another, and acceptance of that other party to the offerer, and then a contract is formed. There's lots of complexity about what constitutes a contract and what constitutes a breach of contract, and all these sorts of things. It's a complicated, separate commercial area, and if anybody wants to focus in particular on it, then I'm happy to work with them on it, but it isn't one that has a whole lot to do generally with things in an educational context, so I don't propose to focus too much on it during this course. Torts is another huge area, the next big area in private law. And torts is essentially to do with disputes and between individual private disputes between people, and the kind of the granddaddy of them all, the original case to sort of illustrate what torts is about is the case of Donoghue and Stevenson, which goes back to the 19th century, where a woman in Scotland bought a bottle of ginger beer, drank her way to the bottom of it, and found in the bottom the remains of a rotting snail, and it made her ill, and she was repulsed and all the rest of it. So she went to court, and the issue for the court was who, if anybody, should be held responsible for what she encountered. Was it the person who brought her the bottle from the bar? Was it the person who sold the bar, who owned the bar? Who was it? And in the end, the court decided that the responsibility lay with the manufacturer of the ginger beer, and that manufacturer had a duty of care to their ultimate customers, and that duty of care was breached by the presence of the snail, and so to compensate for that breach, they were required to make a payment. So that's the sort of example of what you find in tort law, and tort is an example of common law. Common law I'll talk about later, because that's a really important kind of thing to understand, but this is this category of torts. Now, talking to people who teach courses like this in Australia, one of the biggest areas of education law in Australia is to do with negligence and to do with responsibility for injury, and I don't propose to do anything about that in this course at all, apart from explain why we don't do anything about it, because New Zealand has this unique system. Perhaps people have had some interaction with it before, the Accident Compensation Corporation or Commission system, the ACC system. And the ACC legislation that was introduced in the 1970s means that you cannot take legal action against somebody else, which would be an action in tort, for causing you personal injury. So if the damage that you suffer is personal injury or even death, then the remedy for that through the accident compensation legislation is a payment from the ACC, and in return for that payment for the ACC, and to get that payment, you don't have to prove anybody did anything wrong. You just have to prove that you suffered the injury, and then the ACC gives you a certain amount of money to compensate you for that injury, for that loss. It's called a no-fault system, and so you don't need to show that anybody has harmed you deliberately to get this. You get it, no questions asked. And what that does is it just removes an entire layer of litigation that almost every other country has, and Australia certainly has it. So, if there are injuries caused because of faulty playground equipment, or bad carpentry where a floor gives away, or somebody going through a window and cutting themselves, or any of that kind of stuff, there is no legal issue other than possibly a kind of an argument with ACC about how much you're entitled to. So that whole area of negligence and personal injury is not not something that you need to have a big understanding of in terms of education law in New Zealand. The next one they mentioned there is property law, and that is divided again into a couple of categories of land law. Again, this is to do with sort of leases and property, and there might be elements that might be important here in terms of education, and we could have a look at that later on if that's something you especially want to have a look at, but I don't propose to go into that in a whole lot of detail. And the other thing is, so there's the land side, and then there's the other property side, which is to do with property that isn't land, including intellectual property. And maybe there are things there we want to discuss too. We'll have a look at that a little bit later on. The next category here in private law is family law, and this is a whole separate area of activity, and it is something that in education you sometimes have to, you at least need to have some broad understanding of, in terms of custody arrangements and access and court orders and various things like that. And the family court system is one of these areas that's a kind of a distinct part of the legal system that's appealable outside of family law, but is a sort of an autonomous branch of law in itself. That's important to understand some of the basics of that. We won't go into much detail about restitution either. Then there's a discussion about international law, and the international law one is interesting. I mean, in that case that we talked about, the Batterson case, international law was relevant in that the judgment considered international law. It considered international agreements that New Zealand had signed up for. It doesn't mean that the New Zealand courts are bound by those agreements, but it means that they are influenced by them. They can't simply dismiss them and pretend they're not there. So they're kind of fuel to the fire, if you like, of a case. They need to be given appropriate recognition in various things, and education law, areas to do with rights of the child and so on, are significant factors that, as you saw in that case, can't simply be dismissed. Then there's the whole area of equity, which is another part of common law, which is a whole separate thing. Wills and estates are part of that, and so are other things. I don't propose to deal with the area of equity at all. So they're broadly the categories of law, and the reasons why we will be focusing on some more than others, and that's kind of how the various branches of law, of legal analysis, are divided up in New Zealand.